So your articles of incorporation actually create that legal entity, and then your bylaws govern that legal entity. You know, all the ins and outs of, you know, the directors and officers and elections. So that's kind of how those go hand in hand. And then you have your rules and regulations and policies. Your CC&Rs, if they provide that the board has the power to create certain rules and regulations, the board can then create those rules and regulations, usually just called policies, and they could vote to adopt them and send them out to all the owners. Then you arguably have to comply. Yes? That is a question that there have been volumes and volumes. Oh, the question was, if a homeowner purchases a property subject to a certain set of covenants, which is thereafter amended, why are they responsible for those new amendments? Is that, yeah. Right. Right. Yeah, and I'm actually going to get into that a bit. But yeah, that's a good question. I could spend a lot of time answering. You know, when you purchase the CC&Rs, they state that they can be amended by a certain %. And so you acknowledge that when you purchase a property subject to these CC&Rs. Now, usually those CC&Rs require that in order to amend, the members, usually meetings called, there needs to be a quorum of members present at the meeting, and then a vote needs to be taken. Each set of CC&Rs is different, so I can't tell you what, you know, yours says necessarily, but that's the gist. And it's not easy. So they have to send out notice of this change. If you know, do not agree with the change, it's a democratic process, and you have the right to lobby against it. You can go door to door and, you know, talk to your neighbors, and you do have some of those rights, and obviously you'd vote against it. If it does pass, then you're arguably just subject to it. But it's, you know, read your CC&Rs when you purchase a property in a subdivision. And my number 2 piece of advice is to get involved in your homeowners association. So many owners complain and complain because they don't like the way things are ran. They don't like the board. You know, they didn't enjoy the last annual picnic. Well, if you don't like it, then be a part of the solution. I mean, boards are more than thrilled when an owner steps up and wants to be involved in helping change the association for the better. So I would encourage an owner who maybe is contesting an amendment to try to run for the board themselves. Get on that board and be part of the solution if, you know, that's not what you want. Does that answer? If not, I'll give you my card and we could chat and I'll answer it. Here's just a little hierarchy chart. You know, CC&Rs and the plat have ultimate authority. Underneath those are the articles of incorporation and the bylaws, and then the rules and resolutions. So the whole idea is rules and regulations cannot contradict the bylaws or the CC&Rs, right? Bylaws cannot contradict the CC&Rs. To the extent that there's any conflicting language, it's null and void. And of course, all of this needs to comply with the law, which is what's coming up next. Freddie really spoke about this part. Okay, so associations are susceptible to fair housing complaints and violations because, first of all, they have these archaic covenants that they think they need to, well, that they need to enforce, and they maybe don't have the knowledge or the training that there are some potential violations of the Fair Housing Act. And so together with those, you know, the old set of documents an attorney hasn't reviewed, along with their lack of training, that tends to lead to a lot of issues. There are two primary types of discrimination with homeowners associations. There's disparate treatment, which is when intentional bias is alleged. So unequal enforcement of the CC&Rs and policies based on bias, outright discrimination, and then, you know, failure to provide a reasonable accommodation or modification for a disability. So there are cases where, you know, associations, none of my associations, but associations have just they had outright discriminatory language in their CC&Rs, and they enforced it. Or even if they didn't enforce it, they still need to change it, and they took no steps to change it. So while none of my associations would do that, it does happen. And I think with education and with proper training that, that can alleviate some of those claims. I'll talk about them each here in a second. The second, less known type of discrimination that's really become prevalent lately is disparate impact. This is less, I mean, it's more difficult to realize you're discriminating because really all you're doing is usually enforcing a neutral policy. But it just happens to have a discriminatory effect, even though you had no intent to discriminate. And it's when a neutral policy or covenant will disproportionately negative impact on protected classes. So, be aware. That's where attorneys, and also you don't need to come to me, but just go to any attorney, one preferably that specializes in HOAs and fair housing. Single family housing. That is very common. So, if I understood this correctly, an owner was told by someone on the board that they were violating the CC&Rs because they had more than one family living in a single family housing development. Is that correct? Now, the CC&Rs usually do include some language, some single family language. Almost all of them do, actually. But I can't really give you legal advice, but a real concern becomes when there is additional language in there that could potentially disallow group homes. Okay, well, yeah, you would definitely need to comply with the ordinance since that trumps the CC&Rs. And, you know, it needs to be applied equally to all owners. And I'm going to give you some really great practical tips at the end to make sure that compliance is fair and equal and that no one's being, you know, discriminated against. So, all right. Now, with the disparate treatment portion, there is an exception for age-based discrimination, and that's with when 100% of the homes or units are occupied by persons 62 or older, or 80% or more of them are occupied by at least one person who is 55 or older. That's a I call it the 55 and over housing, or HOPA, the Housing for Older Persons Act. And I don't know, has that been discussed at all? Okay, so you're all experts. You don't need this. But I have a lot of associations who qualify as 55 and older, and you know, the biggest thing is to make sure you're in compliance with those requirements to be, you know, a duly recognized HOPA community. So adhere to the policy that demonstrates an intent to house older persons. I mean, there are requirements, they'll talk about it later, and I also have another slide, I believe, on them. But you have to give a survey to the members and, you know, documentation to verify that you're in compliance, and the standards and policies need to be recorded. You know, you can't just decide one day, hey, we're going to be a 55 and older community. You have to follow the policies that are in place to receive the protections and be exempt from that age-based discrimination.
So I have a question from the web. How do you just suggest that we deal with real estate agents who feel that it is not their job to know what the CC&Rs say?
I say, if you're buying a house, well, if you're buying a house as an owner, I know I'm an attorney and I like to read the fine print, but it's my responsibility to know what I'm purchasing, to understand what is, you know, if it's part of a subdivision, what those requirements are. I believe it's my duty as an owner. Now, I'm not familiar with the requirements for real estate agents and whether or not what they're required to disclose. I know they do provide a copy of the CC&Rs at closing, and they are required to disclose that they're in an HOA and there are assessments associated with that. But other than that, I'm not sure what their liability is, really.
So we've worked on this issue because we want to make sure if your CC&Rs contain a discriminatory statement, it is a violation under 804C. And so we don't want realtors who are helping sellers or buyers to engage in that, to help enforce those. So the question and concern has been when you're not aware in the CC&Rs that there's a discriminatory statement. And so we've been strongly encouraging, because if there is going to be a case or is a case, you don't want to be accused of a fair housing violation. And so it's just, and the concern of realtors that we hear is that they're concerned about the length of time and that to read the CC&Rs. And so, but we're just strongly encouraging, we're going to encourage them to do so, just so that, you know, they stay out of fair housing, questions of fair housing violations. So.
Thank you. Okay, one issue that comes up quite often, it's not an issue, but one fair housing component that comes up is reasonable accommodations and reasonable modification requests for those with a disability. For reasonable, have you discussed this already? I don't want to be overly redundant. But an accommodation is basically a request for a change in the rules, policies. So a variance from the CC&Rs, for instance. If I require maybe an improvement to my house that might actually be in violation of the CC&Rs, but it's due to a disability to help me enjoy my property, then first of all, you should contact an attorney, but you need to provide that accommodation for them. You've talked about, the due burden, all of that, that defense, okay, so I won't go there. But, you do need to modify your governing documents, or, at least provide an exception or variance for those owners who do request a reasonable accommodation. And a modification. I hear about that. Always. Move to Florida and then you'll appreciate it. Well,
sometimes they're children of their parents brought it, and now they're living in the house.
and they're responsible for assessments.
And then all of a sudden they're getting stuck with all these, all the rules and assessments. And I get people that are sued on the assessments, which is really interesting.
I do that. It's called cash flow enhancement for the association. I try not to. I try to work something out and,
Well, it turns out you don't have to explain this. There's like a whole bunch of legal things that happen, including liens on their property,
Mm-hmm.
even taking them to court, even foreclosing those liens, and a lot of other things that, I guess are outside our topic today. People complain usually because they haven't paid the assessment.
Mm-hmm.
Or they complain because it's too high. But the most common complaint I get is, I can't talk to anybody. I can't get anybody in the association to listen. There's some policies
Right.
don't like whatever it is. And I guess you've addressed it. I'm just expressing the frustration
No,
that I talk to.
I hear them on a daily basis. What I can say to that is, again, try to be part of the solution. Try to run for the board yourself, although usually that requires you pay your assessments. But, that doesn't mean you can't be on a committee and try to make, affect change. But another thing, and I will only briefly touch on this because it really has nothing to do with fair housing. Owners complain about paying assessments all the time, right? Now, if you look at it from an owner who's paying's perspective, if one owner doesn't pay or 20 owners don't pay, all of those other owners who are paying have to pay more. And so as a fairness concern, I mean, everyone should be paying, and that's part of the board's job, is to equally enforce the covenants. They can't pick and choose who to enforce them against. And, you know, boards, especially all the boards I've worked with, and even my law firm, which we do some assessment collection, we're all really reasonable and fair. We call out, you know, maybe 10, not 10 times, but a couple times to try to discuss it with the owner, to try to reach a payment agreement, to try to help them in any way so that eventually we can get current on our assessments. Sometimes they don't react to our requests, so. We could talk after. Okay, so an accommodation, and then there's the modification, a change in a physical structure of a home unit or common property. And I'm going to talk about how to approach each of those with best practices. But one thing to note, if an owner requests a ramp for the common area, say the pool house, right? That would be a reasonable modification request. They could, you know, the ramp could be installed at that owner's cost, right? Yeah, okay. And then as far as the reasonable accommodation, if that owner wanted a ramp to their house, which is their private property, not common property, and it looked, you know, according to the CC&Rs, maybe the CC&Rs don't allow ramps, which you should definitely amend those ones. You know, they can request an accommodation from the board, and then, you know, hopefully the board accommodates, and they get their ramp. And that's more of an accommodation because it's on their own property, giving them permission to do something as a variance to the CC&Rs versus a modification of that common area. Okay, I think you guys spoke about this already, right? Oh. So these are common complaints that are raised against associations. Most of them have to do with disabilities and accommodations. A lot of them are related to service animals, emotional support animals, and you've discussed that. Parking, someone wants to change a parking spot because maybe it's, you know, their disability requires them to be closer to their unit. Well, I'll talk about the process for responding to that. But just if it's a reasonable accommodation, probably have to grant it. There are some nuances with this, like if the difference with this in homeowners associations versus tenants in apartments. In apartments, the apartment complex owns all the parking. So they can swap out parking, give you a new parking spot. Well, in some associations, the actual parking spot is deeded along with the property. So an owner owns that particular spot. So for another owner to want their next door neighbor's spot, well, they can ask them, and maybe they'll trade, but there's nothing the association can do more than ask. Now, what they can do, however, they can perhaps, if there is some guest parking or common area parking near their unit that would be more accessible, they can suggest that as a solution and trade parking spots. You know, there are some very creative solutions, not always necessarily what would be best for the person requesting the accommodation, but an association can really only do so much. I can't take someone's personal property and give it to another person. I could definitely try to accommodate, and we could be creative with that. So we talked about ramps. Group homes, if they have 8 or fewer persons with disabilities or elderly persons living in a home, don't kick them out. Even if your CC&Rs prohibit group homes, if your CC&Rs prohibit group homes, you should probably amend that out. Disparate impact. There's a great 2013 HUD publication that I encourage you all to read called Implementation of the Fair Housing Act's Discriminatory Effects Standard. It's great. Do you have a copy out there? It's online. And here is one major, well, it's a trend I've been noticing in homeowners associations with some of these fair housing claims, and it relates to disparate impact, and it really has to do with unintentional discrimination against families. So I'll just read the statement from the Department of Justice. The Fair Housing Act prohibits housing providers from discriminating against families with children. This means more than just allowing those families to live at the property. It means giving these families fair access to the common areas and amenities. So look at your pool policies, look at your common area policies. Really have, seek advice, legal counsel on whether or not those maybe as they've been implied could potentially have a disparate impact. And I'm sure Zoanne would love to assist with that as well. It's hard because associations don't always realize that as applied, some of their covenants could have a negative impact on families' ability to enjoy their property. And, all they're doing is equally enforcing their covenants without realizing that maybe there's that impact. So I just encourage homeowner associations to, if anyone raises a complaint and it looks like it could potentially have anything to do with this, to take them seriously and to work with them to resolve it. And I'll give more examples here in a second. What are we on time? Oh, great. Okay. So have you already gone over, Zoanne, the process? Okay. So we have the enforcers, HUD and the DOJ. Then you have the complainants. If you do something, well, it doesn't really matter what you do. Anyone can file a complaint against you. An owner, for instance, or a tenant, in fact, can file a claim requiring the HOA respond. The association needs to respond in a timely manner, and then HUD will conduct an investigation to determine the merits of that claim. So they'll do interviews, they might do a site visit, they do a very thorough investigation. Then IFHC, then you get a call from Zoanne, sorry. Well, you'll probably get a letter, actually. They typically join an owner's complaint, right? Is that just standard practice? And they also will review your governing documents for potential violations and ask that you correct those. I can help you correct them if that happens. I've done it a few times. Okay, so if there's a complaint filed, the response investigation, you then have an opportunity to reach a conciliation, to really talk and be part of this interactive process of resolving the complaint. And, conciliation is a heck of a lot cheaper than potentially litigating this in federal district court. So a lot of times, you know, it's just a good rule of thumb to try to conciliate. And then if there's no conciliation, which has happened in, I believe, one case I was involved with, it was just a very bizarre claim, and we decided we wanted HUD to make a determination as to whether there was a reasonable cause to actually have a lawsuit filed. So in this case, luckily, HUD made a determination that there was no reasonable cause and it was dropped. But, you know, they could have gone the other way. If they had determined there was reasonable cause, then an actual lawsuit could be filed. And that's typically in the federal district court, or you can opt for an administrative agency hearing. And so those are your two options, and I believe it's up to you. The damages are, I know the tenant attorney, or the landlord-tenant attorney yesterday talked about some of these damages. They're bad. You don't want them. You know, you can get there could be injunctive relief granted in favor of the complainant. You could have actual damages against you, out-of-pocket expenses, you know, their fees and costs and fines and penalties. And if there's a court action, so if this goes to district court, then it's the same as the above, but plus you get punitive damages if they win, assuming the complainant wins. Or, you know, it will be HUD at that point. And insurance, if you have insurance, first of all, I wouldn't serve on a board if there wasn't a great D&O policy in place. Make sure you have insurance. Very important. However, insurance doesn't always cover this sort of defense. So they may or may not pay for your defense or for a judgment if you lose. Here's the solution. There's a solution to all of this. You be proactive. So, you know, participate in training. These sort of things are great. Everyone's really learning the law, and now we're all going to comply and hopefully not have any complaints filed against us. But also have an attorney. Not necessarily me, but any attorney who's familiar with fair housing. Review your CC&Rs and governing documents, including your rules and regulations and policies. Amend them if possible. Even obviously you aren't going to enforce something in your CC&Rs that is a violation of the Fair Housing Act, but sometimes simply not enforcing it isn't enough. Sometimes you need to at least try to amend it out. Spending, I've already talked about that. Okay, adopt standard procedures. Standard procedures in place will help you in the future from a discrimination claim, at least in some cases. So, you know, also have standard procedures for responding to accommodation requests. Have an attorney review those procedures. Then you don't maybe need to see that attorney again. You could follow the procedures they provided. Also, you know, keep notes on any variances that are granted or requested, and as well as the Architectural Control Committee requests. This promotes consistency and enforcement. You are, you know, enforcing the same covenants against every owner, and it helps guide the board. You know, there's a lot of turnover on boards. Some people don't want to make a career out of it. So, you know, every year there might be a new board, and having policies in place to help guide them to equal enforcement and consistency really will help your association function and stay in compliance. Keep good records, be professional and civil. Someone files a complaint, work with them, you know, obviously. Also, just as an association, try to be as inclusive as possible. Organize community events that include children. Don't try to exclude children from events. Choose locations for your board meeting that are physically accessible. And if you're relying on the Housing for Older Persons Act, then ensure you qualify and maintain that status. And you'll have, are the copies of this available for them so you can review all of this? Am I out of time? Oh no, just kidding. So wait, one last thing. If anyone mentions anything that could appear to be a reasonable accommodation or a modification request, take it seriously. You know, go to an attorney, get some legal advice. Don't just respond and say the wrong thing, because that can get you in a lot of trouble. I had an association that came into my office the day they received what appeared to potentially be a request for an accommodation. I was able to, you know, luckily they retained me, because otherwise I think they would have potentially asked for all their medical records, even though it was apparent that they were in a wheelchair. So that's another reason you should seek legal counsel before actually responding. But then once you know, do timely respond and be part of the interactive process, know what you can and can't say or do, and it'll take you a long ways. When they don't want to approve a what? So if is the developer still in control? What do you mean? Okay, perfect. Yes, so an owner who wants to build a storage structure potentially on their own lot. Is that your question? Is your question what do they have to do, or? Did he already build the structure? Did he apply for Architectural Control Committee approval? And did you approve it? Well, it would depend on what your governing documents say. It's very fact-specific, and if you want to talk afterwards, I can maybe help you out a little better and get some more information from you. So what happens if one owner was denied a storage unit while there are other owners in the community who were not denied the storage unit? And did you have something? Okay. All right. Well, that happens. It depends, again. Everything depends on your governing documents. If the governing documents specifically prohibit all structures, such as sheds, then no one should have a shed unless there was possibly a grandfathering in, because the amendment was passed after people had owned units and built sheds. You know, it's equally enforced, especially if it's a protected class. You want to make sure that you have all your ducks in a line. Again, that's where documentation comes in handy. So I like to think if some people have structures that were approved by the ACC, that they kept really good records, and I hope there's a really good reason why they didn't allow this other person to have a structure. And I'm hoping that all of that would be apparent by the great record keeping. But you know what? Work with that owner, talk to them about their concerns, maybe try to come up with a solution before you receive a complaint. And if it was a reasonable accommodation request, follow those steps provided in my prior slide.
So I have a question from the web. Have you had specifically you, experience with a HUD complaint? Is it expensive for an HOA to deal with a complaint? And how do the attorney fees get paid? I am a homeowner. How will I know there is a HUD complaint, or will I even know if I'm not currently involved with the HOA and just pay my dues?
Get involved. Go to meetings. This is all public record. If, you can request copies of public records and be part of this. If you attend the meetings, I'm sure they discuss some of these issues. Now, they might not go into all the legalities because some of that might be privileged information, but it's fairly easy to just ask, and just ask them. They should give you an honest answer. Now, I have dealt with quite a few complaints, and in a handful of them, I actually say, in the majority of them, they were resolved through really just talking with IFHC and helping the association follow the proper steps to get them in compliance. A lot of them are little things such as, but they're important. A lot of the issues were old covenant language that maybe, even though not enforced, maybe it violated the Fair Housing potentially, the Fair Housing Act. And so I assisted those associations in creating amendments, and they went door to door, some of them, and received the necessary approval. In other cases where that couldn't be obtained, we adopted a resolution clarifying that this particular provision would not be enforced. There are ways we have some creative solutions to issues, and we tend to try to work with the complainant to resolve them so that it doesn't escalate. Now, that is probably around, I don't know, to write an amendment and help you with that is probably around $500. Whereas if you have to respond to a complaint, it could cost like 10 grand. I had a handful of cases that cost about 10 grand. Some of them a lot less. It really just depends. It depends how willing the other party is also to conciliate. If all the, I try to encourage conciliation because none of these cases even went actually or turned into a lawsuit. They were all conciliated or determined no cause by HUD. So I can't even imagine what the cost would be if they actually went to court. Even if you win in court, you aren't guaranteed attorney's fees. You might still need to pay those. So acting in the best interest of your association, it might be in your best interest to conciliate. Now, I like to zealously fight for my client and assist them in every way possible, but also, making sure they're aware of the risks and the costs associated with proceeding some of these actions and some of the benefits of really working things out when there is a complaint. This person's probably your neighbor. You have to live with them. I mean, I'd rather not have to see them in court every day also. I'd rather just resolve it personally. But that's, up to the association. That's not up to me.
Sarah, I just wanted to make that's one of the reasons is that I had Sarah come today. She's really good about problem solving these things, and so I super appreciate that, because some of the times some of you have engaged attorneys who are not familiar with the Fair Housing Act and also who do not do their due diligence, do not research the law. And in a recent case that we had where we brought in a private attorney to assist someone, where the HOA, despite our good educational efforts and despite engaging the attorney and tried to educate them, they went to put a lien on the home and foreclose on it, and they lost. They lost, and they ended up paying over $48,000. And so it was a discriminatory action against a group home. So I want people to make sure that it isn't, when you get bad advice, it is specially assessed against you. They did end up paying the for the attorney and for the bad advice they got. And so I want people to be aware of that. So when we look to resolution, when we file these complaints after we've tried to educate people, I ask them if they didn't involve the community in making that decision, that it be only specially assessed against the HOA board members, because those are the ones that make the decision if they did not involve the community as a whole. And I want people to know that, so that if your community gets angry about that they know we try to negotiate it so that it's only those who we've tried to educate and have made a decision to act adversely anyway, that it's particularly only against them. So I want people to know that.
We have another question from the web. What is a reasonable time to respond to a reasonable accommodation request?
It depends. Well, you know, get an attorney as soon as possible to see what the appropriate response would be, because you certainly don't want to ask them something you shouldn't be asking them. And, you know, it doesn't hurt to immediately get back to that owner and say, we received your response. We will be in touch with you. Just let them know, keep in touch with them, let them know you're in the process of resolving it so they don't feel ignored, because it's often when communication lapses that, you know, owners or these complainants or owners that request a reasonable accommodation, they might think nothing's going on, while a lot really is going on in the background. So just keep them informed throughout the process.
Thank you. So up next is, you got to be set up. Next up, we have Gary Haynes with Gary Haynes Associates on Limited English Proficiency.
Can I use this?
Yes, but you have to eat that.
I'll try to do it quicker. Good afternoon, everybody. I probably should start my presentation with a disclaimer like some of my friends did this morning and let you know that I am not an attorney and that my opinions are my own, but I am very passionate about them. Hopefully that'll make up the difference between not being that and not being an attorney. This afternoon I'm going to talk a little bit about Limited English Proficiency, which is that part of the Title VI of the which is part of Title VI of the Civil Rights Act. And my presentation today versus what I presented yesterday is more emphasis on state and local